Good morning, everyone, and welcome to this webinar today on SEN funding challenges and duties, particularly the duties of the local authority in relation to funding of special educational needs and the provision that comes with it. So in terms of the agenda for today, I've set that out in the next slide, which will take us the webinar. I will try to take you through legal considerations around clawbacks when a pupil is not attending school, ways to ensure that your schools can successfully challenge local authority decisions, an overview of local authority NHS duties in relation to funding of a special educational provision, and then we will touch on EHCP shortfalls. That's where you have deficits in the provision that you're making versus the funding that you're being given by local authorities. I will touch on funding alternative provision and what that means in practice. And then we will look at some practical steps as to how you can build a case to start that conversation with local authorities in relation to funding shortfalls and deficits at your schools. Next slide, please, Taima. So I suspect that all of you are here today because, sorry, somebody's saying as the image is on top of the speaker, the slides are not showing at the bottom. Is that everyone's issue? I am seeing it correctly. If you could let Taima know by the chat. So most of you are here today. Yes, so others are saying that they can see it correctly, so I'm going to continue in that case. So most of you are here today because you are having difficulties securing that funding. You're overspending out of your budgets rather than the money coming from the local authority and so on. This is in line with the SEN landscape of funding at the moment in England. Helen Hayes, who is the chair of the Commons Education Committee that is leading the SEND inquiry at the moment, recently wrote to Catherine McKinnell, the Minister for School Standards, asking her to set out her plans on any changes and described the SEND crisis as the most significant challenge facing the education sector. The scale of the problem is very large indeed. The National Audit Office has estimated that the deficit in the high needs block is of 2.9 billion, or will be. They had estimated that it will be by the end of April 2025. I think it has been in fact exceeded and is now over £3 billion of deficit to the high needs block. This means that we now have 55 local authorities taking part in the voluntary Delivering Better Value programs, 38 local authorities and the safety valve agreements, which have now been stopped. So there will not be any additional local authorities joining safety valve agreements. And the DFE seems to now turn in focus to early intervention to avoid unnecessary issuing of EHCPs and undertaking a review of the EHCP system and inclusion. There is a white paper on SEN reform in the pipeline. However, the current government is completely silent as to what this might bring in terms of changes. There will have to be some changes because there are estimated 1.7 million children of compulsory age with SEND in England. And of those, roughly 450,000 have an EHCP, which is 4.8% of the children in education. Next slide, Taima, please. So the main challenges that the schools are experiencing are this. You are receiving an increased number of consultations and an increased number of children with EHCPs. There is, however, a lack of clarity on the EHCP funding that you're receiving for those children. Often it is the case that the schools start making the provision and they realize that the EHCP is woefully inadequate and the funding attached to it is inadequate too. And they're having to fund out of their own budget whilst they are negotiating with the local authority. There are delays in securing the funding once those conversations start. Schools are having issues as well with recruitment of specialist staff and staff retention around SEN because of all the other pressures that the schools are under at the moment. And compounding all of this are the delays by local authorities in undertaking education, health and care needs assessments, and delays in the EHCP process. Next slide, Taima. So the Children's Commissioner agrees mostly with what's happening in schools and what the Children's Commissioner is being told by schools. And in their last report, they were very concerned about the latest statistics in relation to SEN. So the tribunal appeals pending at the moment are exceeding 21,000. Of those, we know that the vast majority of them, so 98% of appeals, come down in favor of parents. That's either partially or fully in favor of parents. And therefore, in my view, there needs to be a real rethink of whether local authorities ought to be defending these cases, given the very poor success rates for local authorities when appeals are being brought in relation to EHCPs. 1/4 of the cases brought on appeal are against refusals of the local authority to carry out an assessment. The majority of those fail. The threshold is relatively low. This means that families are left unable to get the support that they need. And we know from the Children's Commissioner analysis that the children that are particularly affected are children with ASC, so autism spectrum condition. And within those particularly affected are girls in the education system who often are under-assessed and under-detected within educational settings. There are also long waiting lists for new assessments and all sorts of other assessments. And the waiting time for the local authority to assess is growing as well, often in breach of the SEND regulations 2014. Now, the problem with the LA incurring deficits goes back to when the Children and Families Act came into force in 2014. What has happened in essence is that as a result of the Act, the provisions, so the rights attached to the provision have increased, and the high needs funding has not increased in line with the needs of the children and the rates of children that have EHCPs. So this trickles down to schools who are expected to foot the bill for this special education provision and blurs the lines between the local authority duties and the school's duties under the Children and Families Act. We hope that the white paper will deliver what it has promised, which is a complete recalibration of the SEN system, but at the moment is unclear what to expect from that. Now, looking next at the framework, the legal framework. Taima, please, the next slide. So all of these acts that I've cited here are relevant to funding and educational provision, both in relation to maintained schools and academies. The Children and Families Act is your main act in this conversation, and it secures the general presumption in law that children and young people with SEN should be educated in mainstream education settings. The Special Educational Needs Improvement Plan of 2023, published by the previous government, reiterates that meeting SEN will remain a core part of the mainstream school role in the future. And it sets out how this should be done. However, there was no overhaul of the SEN funding system with that improvement plan, and therefore we're left back to square one where we were before the improvement plan. Now, the SEN Code of Practice has everything that you need to know in relation to the statutory guidance to which schools must have regard in relation to your legal duties to pupils with SEN. And moving on to the next slide. In some more detail, the main duties in relation to funding, without taking it to a much more granular level, are for the local authority in section 42 of the Children and Families Act. The local authority has an absolute duty to secure the provision in the EHCP of a child in education, and that includes the education and social care elements, and funding both those elements. It is an absolute duty, non-delegable to schools. The local authority has also a duty under Section 19 of the Education Act to arrange suitable education. I will talk about Section 19 duties a little bit later down the webinar. Tied to these duties are the Integrated Care Board duties. The ICBs have duties under the Children and Families Act, Section 42. 3, which is the duty to secure health-related provision in EHCPs, and that is again an absolute duty. So you can remind your ICBs and your local authorities that they have to talk to one another when it comes to provision in the EHCPs in sections F and G, and that it is for them to resolve disputes in relation to who is funding what, but they both have an absolute duty to fund healthcare, education, and social care elements. The NHS Act, Section 3, NHS Act 2006, I should have said, Section 3 imposes a duty on the NHS to arrange health provision, including nursing services in schools, if necessary, to such extent as it considers necessary to meet the reasonable requirements of the persons for whom it has responsibility. It is always worth bearing in mind Section 3 of the NHS Act, particularly for specialist schools when they're being asked to step into the shoes of the NHS in relation to non-delegable activities and to fund health provision within the schools. So in sum, on the first 2 bullet points, the education and social care elements must be funded by the local authority, and the health elements must be funded by the ICBs in the local area. Now, the schools have related duties, so they have a duty to admit a child, a young person once named in an EHCP, and that's Section 43 of the Children and Families Act. And they also have a duty to use best endeavours under Section 66 Children and Families Act. And I should have added there that you have your overarching duties under the Equality Act, and there is an overlap between the Children and Families Act and the Equality Act when it comes to reasonable adjustments and special educational provision. Next slide, Taima, please. So before we go to look at funding in itself, I wanted to pause just for a minute on how schools can actually spend the funding that they receive. And it's worth remembering what the guidance that we do have in statute and in other documents in relation to how schools can and should spend funds. So in the Education Act 2002, Section 19, Schedule 1, for maintaining schools, the governing body may do anything which appears to them to be necessary or expedient for the purposes or in connection with the conduct of the school. They must act reasonably, and they must ensure the sound, proper, and effective use of the school's financial resources. This also means the sound, proper, and effective use of financial resources also means not allowing the school's budget to be used where the local authority should be funding the special educational provision rather than the school. So governing bodies need to be aware of this duty when looking at their own SEN funding deficits and how to approach them. Academies have similar duties in relation to how they can spend funding. The terms of funding are regulated by academy arrangements, as you know, and the Academies Financial Handbook, also known as the Academies Handbook, at paragraph 2.25 says that the Academy must ensure that spending has been for the purpose intended. So if your budgets if you're spending out of the budget that is not intended for SEN, then you are not acting in accordance with paragraph 2.25, and you can remind your local authorities that you need to be acting in accordance with the Academies Financial Handbook, and also the all of the decisions have to be in accordance with your duty to use public funds correctly. Next slide, please. In relation to the source of SEN funding, I am not going to spend very long here because I think you all know this. So schools block funding, 6K that you get, so that's your core funding for your SENCO, your running, your small resources, etc., etc. And then you have your high needs block funding, which is divided into 4 sub-blocks. So it can be used for top-up funding in mainstream schools for individual pupils, which is what we will be talking about here. It can also fund places in maintained special schools and alternative provision, fund places in independent special settings, and provides specialist SEN services, such as outreach. We are primarily focusing here today in this webinar in number 1, so the top-up funding in mainstream schools for individual pupils, although I will touch on alternative provision. Next slide, Taima. So the notional SEN budget, that's the £6,000 that you get, is an indicative amount per pupil. And the so paragraph 6.66 of the SEN Code of Practice states that schools are expected to provide additional support, which costs up to a nationally prescribed threshold. In this case, is the £6,000. The guidance tells us that this is for reasonable additional costs that the school may incur. Costs that are beyond what a school should be expected to pay out of the notional budget would not be reasonable. And then you will be, this helps, the notional budget helps towards the best endeavours duty and the fulfilment of that duty under the Children and Families Act. It is intended as a target and not a constraint, and where reasonable adjustments are required and there is a need for a special educational provision, the revenue costs can be met from the SEN budget. Now, what often happens is that local authorities will say that if you haven't spent your £6,000, you cannot apply, for example, or request an EHCNA, and you cannot apply for further funding. As we will see later on, this is not correct or in line with the high needs funding guidance. Next slide, Taima. So the high needs funding guidance, it's a very important document for all the schools seeking to talk to local authorities about how they are insufficiently funded in relation to pupils with SEN. And sometimes some of the guidance within the document is overlooked by both the schools and local authorities. I guess what the high needs guidance does, it tells us and the local authorities that given that SEN is a legally defined term which opens rights and protections, it also attracts funding, and funding should be allocated in line with a high needs funding guidance when there is a need for something over and above what schools provide out of their general budget, which includes that SEN element. So it supports the provision for pupils and students with SEND who require additional resources to participate in education. It's in school and colleges, not those aged 19 to 25 without an EHCP. And it also goes to fund pupils in alternative provision who, because of exclusion, illness, or other reasons, cannot receive their education on mainstream schools. Changes to high need fundings to schools must be made in consultation with the schools. This is often done, normally done via the schools forum, etc. And there are issues with consultation there, as we have seen in recent case law. And it is not only for pupils with EHCPs, and I want to emphasize this, the local authority, and this is a quote from the actual funding guidance, local authorities have flexibility to provide high needs funding outside the statutory assessment processes for all children and young people with high needs up to the age of 19. So the fact that a pupil does not have an EHCP does not mean that the local authority is relieved from their duties under the Children and Families Act and the Education Acts. Next slide, please. Now, I have included here some, I think, very helpful sections of the high needs guidance for schools to include in their conversations with local authorities. So the first one is around how the DfE expects local authorities to work with the schools and colleges, and that is constructively with the aim of reaching agreement on the overall levels of top-up funding required. There is, it would be very good if local authorities remember this when they're talking with families and schools about the top-up funding level required. The second point is that the local authority should consult with the school in question and should ensure that their funding allocation decision is evidence-based and reasonable. So if you get a funding allocation that you believe is not evidence-based or reasonable, you can cite this back to them and ask them for reasons and for evidence in support of why they're saying that a child should receive funding in accordance with a particular level or banding and not another. And we see that local authorities will often say that the panel has made a decision and therefore that's the level of top-up funding and the end of the matter. Well, the high needs funding guidance is clear that the role of the multi-agency panels is only advisory and that all funding decisions remain with an officer of the local authority. And therefore, it is for the officer of the local authority to tell you why they agree with the multi-agency panels making a decision on SEN funding. It is not enough for the local authority to simply tell you this is what the panel has decided and this is what the funding that has been allocated. The funding responsibility of the local authority should be discharged fairly, reasonably, and after proper consultation with the schools. And the local authority must confirm in writing as soon as the placement is agreed. And again, I find that schools, when I do this talk and other talks on SEN funding in person, that schools often say, goodness, it is only when we get the child, or many weeks or months sometimes after, that we have full agreement on the funding. Well, the high needs funding guidance is clear that funding must be confirmed in writing as soon as the placement is agreed and no later. And therefore, schools that know that there are children with EHCPs in the pipeline should be asking for confirmation and referring back to the high needs funding guidance on this point. Next slide, Taima, please. So now looking at high needs funding guidance in relation to AP, hospital education, and elective home education, and I guess I should have added the EOTs. So Section 19 duty to provide is placed on the local authority, and that is to provide suitable education from the 15th day of absence or 6th day of absence. That can also fall on the schools where the child or young person cannot be educated in school for reasons of exclusion, illness, or any other reason. The majority of the disputes with local authorities happen here in this sort of Section 19, which local authorities seem to sometimes displace onto schools and say that schools have duty to fund the alternative provision whilst they're figuring out where the child is going or what's happening with the EHCP, etc. And for the purposes of this webinar, I am not touching on suspensions or offside provision, which generally, the funding of which generally falls onto the schools. I am talking about the Section 19 duties for all other children. So in accordance with the guidance, the alternative provision will normally be funded out of the higher needs budget. This is because alternative provision settings receive their funding in different ways. And one of the ways is through top-up funding, and that's the funding required over and above the core of place funding to facilitate the education being provided, which the setting receives directly from the local authority or sometimes the school that commissions the placement. The core funding, which comes before the top-up funding, that it's generally funded by the local authority, and the funding guidance tells us that it is for the local authority to fund the core places at AP provision. And then there are some additional locally negotiated funding or alternative provision services, which normally are done by way of a service level agreement. Now, where a local authority commissions a placement for a pupil at a PRU, an alternative provision academy, or an alternative provision free school, the top-up funding is allocated from the local authority's high needs budget. And where a school commissions a place at a PRU, alternative provision academy, or alternative provision, the top-up funding may come from the centrally held high needs funding that has been devolved to that school, or a local partnership of schools, or from the school's delegated budget share, or if an academy from the general annual grant. This is because the high needs funding follows the pupil, including in cases where the pupil has been permanently excluded. And the local authority can, and they do ask schools to divert the top-up funding onto the A provision. Now, schools are not required to fund alternative provision on a long-term basis, and schools should not agree to enter into any such arrangement with the local authority if it is clear that a pupil is not going to return to the school. Then the local authority must take on all of the duties in relation to that pupil. The pupil should come off roll after an interim period. Sometimes I understand that there's some grey periods where it's not known whether the pupil is going to return or not return. But once it is known and clear to everyone that the pupil will not be returning to the school, it is the local authority should not be asking schools to arrange or administer arrangements in relation to alternative provision. The pupil should come of roll. The local authority should take on the Section 19 responsibilities, place it in alternative provision, being clear that alternative provision, and the guidance tells us that, the alternative provision guidance tells us that alternative provision must not be used as a setting where you place a child that in reality needs to be placed in a specialist school. I understand that's the reality of what's happening in England at the moment, but the guidance is clear that it must not be used in that way. So if a local authority is asking you to enter on a long-term arrangement whereby you administer or continue to divert those top-up funds and so on to an alternative provision, the child is not going to return, you ought to write to the local authority and say, no, that's not what your Section 19 duties tell us that you ought to be doing. We're not willing to do this. We want to initiate a conversation about taking off roll. Obviously all the funding, including the top-up funding, would stop flowing to the school, but that must be done to avoid tricky situations further down the line, and greater deficits being accrued as a result of the AP provision costing much more than what the school is actually receiving in relation to that child. Hospital education should be funded by local authorities, but local authorities can ask for a contribution from the school and then they can top it up. Local authorities should not be asking schools to enter into service level agreements or any sort of agreements with hospital education providers, insofar as it is for them to secure this provision and to fund this provision, albeit they can ask you for a contribution. So it is for the local authority to enter into those agreements with hospital education providers, and then schools can top up from can divert some or all of the top-up funding if there is a deficit. So if a school has already diverted their top-up funding and that's not enough to fund the hospital education, then that duty falls on the local authority and they shouldn't be asking you to fund it beyond the top-up funding that you receive. Next slide, Taima. Thank you. Oh, I think we're having an issue with the slides, or at least I am at my end. Next slide, Taima. So now moving on to the high needs funding guidance in relation to health and social care and what it tells us about how health provision and social care provision ought to be funded. The funding duty falls on the local authority for social care, as we know, and that's social care that is specified in sections H1 and H2. Sorry, there's a typo there. In the EHCP, that comes out of from the social care budget. The funding duty on the ICB and NHS England for health provision is for the provision set out in section G. And the high needs funding cannot be used for non-educational costs. So if you're being asked to fund any of the health provision that is specified in section G out of your high needs funding budget, that is not allowed and it's not wrong, it's not correct and not in compliance with the legislation or the high needs funding guidance. So the high needs funding can only be used for educational costs and not for health cost. But health and care, social care provision that educates or trains, if it is specified in section F, then will be funded out of the high needs funding budget. And that's also specified in paragraph 9.74 of the SENCO Code of Practice. But it must be specified in section F, and this is normally you will find your SLT, OT, etc. In section F, and that comes out of your high needs funding budget. Anything in section G does not and must be funded separately. If there is dispute between the agencies, the local authority and the ICB, then the local authority should fund the provision entirely until the resolution of the dispute between the ICB and the local authority. It is not for schools, and schools should not be spending time having disputes with ICBs and local authorities. The single point of contact is under the legislation with the local authority, and it is for the local authority to then fight those battles separately with the ICB if there is a dispute. In the meantime, they must be funding the special education provision and the provision specified in section G. Next slide, Taima, please. So common concerns that arise, I have a series of slides on this. The first one is around delays and funding, and this is delays in the EHCP process. Just a reminder that the SEN regulations are quite clear that from the moment there is an EHCNA request, the local authority has, by statute, 20 weeks to complete the process. Unfortunately, this is often not respected, but you can continually write to local authorities and ask them, are you on track to finish the process within the 20 weeks? And if not, why not? And you can keep your families informed of this so that they can put pressure, because obviously the sooner you have your decision on an EHCP, the sooner you will get funding flowing through to your coffers to make the adequate provision for that pupil. From the request for an assessment, the local authority has 6 weeks to decide whether to proceed, no longer than that. The draft EHCP has to come within the 20 weeks. The regulations do not tell us that it has to come within a particular time frame, but what we do know is the draft EHCP and the final EHCP both have to come within the 20-week window. And all annual reviews must happen within 12 months. Now, what happens where your local authority says, we're not going to undertake an EHCNA because you haven't spent, or we have estimated that you have not spent your notional budget, that it's, excuse me, that is not what local authorities should be doing, because local authorities cannot delegate their duties under the Children and Families Act. The local authority will, as a matter of policy, expect you to have spent the £6,000, but this is not a requirement as a matter of law. And you can push back on that where you think that you may not have spent your £6,000 budget, but it's very, very clear that the child or young person requires an EHC plan for reasons other than having funding attached to the plan. So the legal test that applies here in those cases is set out in section 36(8) of the Children and Families Act, which says that the local authority must identify and make an assessment of those children or young people in their area who have or may have special educational needs and who may need a plan. So it doesn't say for those children in respect of whom schools have spent their notional budget. All they need to be satisfied is that the child has or may have special educational needs. It is worth reminding local authorities of that duty when they come back to you and say, we do not believe that you have spent your £6,000 and therefore this child does not require an EHC needs assessment. Next slide, please. So I guess what I'm saying is that there is no requirement for a particular spend to happen before you can request an EHCNA. All the SENCO practice tells you is that you need to use your graduated approach before you request a needs assessment. The second common concern is around EHCP funding gaps. So that's where the EHCP tells you that a particular child is getting £7,000, whereas you know on the ground you're spending £12,000. So what happens with that £4,000 deficit? You will be your best port of call in those circumstances is to call an emergency annual review, where you will be providing detailed evidence of why you think that the funding the deficit in funding has happened. You will have your cost of provision maps, etc., and that is your first port of call to. That's how you initiate that conversation with the local authority. If the local authority do not engage with you at that point, you can consider making a formal complaint to the local authority. And you would use the complaints process. I find that when our schools use the complaint processes of the local authority, it gets their attention rather than emailing the same caseworker who has already told you, no, we don't agree with you. We think that funding is enough. You can use the formal complaints process of the local authority. If that doesn't bear any results, then you can complain to the Secretary of State and ultimately you could apply for judicial review, albeit that's a very, very costly and legally involved process. So, and you must have exhausted at least the formal complaints procedures to the local authority before you move on to more robust legal routes. And again, with the NHS funding, I am not going to stop on that. I've already talked about that, but you can remind the local authority that it is them who need to be having that conversation if there is a funding gap. So please, basically the main gist of this slide, do use your formal complaints procedures to the local authority because they are sent via a different route and a different person is looking at it rather than the same caseworker from the local authority that has been working with you. Next slide, please. So the third common concern is around clawbacks. So when pupils are not attending your school and the local authority may attempt a clawback of funds, which are triggered often by non-attendance. The main question to ask there is whether the provision, so your education provision or your offer is still required. If it is not required, then you go back to what I said earlier to starting to talk with the local authority about a change of placement and with the family. You ought to consider whether the absences are health related or due to inadequate support. If health related, the alternative provision guidance, it's quite clear that local authority must fund the provision, although they can ask you to contribute the top-up funding, but no more. If it is due to inadequate support, you will be triggering your EHCNA processes. So the local authority looks at what provision needs to be made in addition to that provision that you are currently making. And the legal test there is whether education is still being delivered or attempted. If education is still being delivered or attempted at your school, then the local authority can ask you to contribute to the alternative provision or whatever it's happening from the top-up funding. But if education is not being delivered or attempted, then it's an entirely different scenario where you talk to them about deletion from register and what's going to happen with that child, obviously in collaboration with the families and in collaboration with the local authority. There is a risk sometimes of a clawback of fundings without proper review or a very long-term arrangement. So again, just watch out for that pitfall. Next slide, Taima, please. So how can you challenge the local authority's decision in relation to local authority funding? The primary advice there is on an individual pupil basis to challenge local authorities at very high level because their policy is wrong, their banding is wrong, etc. We have seen that those challenges fail over and over again when they get to the High Court, because the High Court is not interested in that. They think that that's a matter for local authorities to decide and not a matter for them to decide. If you want to successfully challenge a local authority decision in relation to funding, the best thing that you can do is to have a spreadsheet in relation to all of the children whose needs exceed your notional budget with reasons, and to start a conversation child by child. And this applies trust-wide. If you have a big academy trust, you can have a devoted person looking at where the deficits lie and initiating conversations school by school on a very methodical basis, but it has to be on an individual pupil basis. You will also ensure that sections B and F are specific and quantifiable. If they're not, then you're calling your emergency and reviews, because if they're specific and quantifiable, they're likely to attract, or more likely to attract, the correct level of funding. You can call early assessments as well if you think that the child is very likely to require additional support. You will look at how you're costing the provision and whether that's being done appropriately and in conversation with your business managers and your SENCOs and the class teachers and so on. It is a very holistic exercise to find where the deficits are so that you can talk with the local authorities armed with data and evidence as to how you want them to resolve the dispute. You can also provide robust consultation responses with evidence, and within the consultation response, include your views on costings. I always advise that. It helps later down the line if the provision is not being funded at an adequate level. You clarify the funding that an EHCP attracts at the outset with reference to banding if it's used by the local authority, and a reminder of the high needs funding that EHCP funding must be, and high needs block funding must be agreed before placement starts. You can request reasons from the local authority as to why they're disagreeing, because it is those reasons that you will eventually potentially be able to challenge either by way of a complaint to the Secretary of State or by way of judicial review. You ought to be firm as a school in relation to the local authority's duties, which are non-delegable, and the fact that you should not be asked to step on their shoes. You can request emergency and reviews and highlight any failures to reassess, assess, or review an EHCP to the local authority. Again, all of this with transparency with the families who will be likely supportive of your efforts and can themselves put pressure on local authorities to increase funding. Next slide, Taima, please. So just a few notes of caution in relation to pushing back on funding decisions. You still have to keep an eye, very firm eye, on your Equality Act duties to make reasonable adjustments, albeit you can fund those reasonable adjustments if they are special education provision out of the high needs funding block. You you still have a duty to admit under the Children and Families Act, even where the funding allocated is insufficient. You will be mindful of your relationship with the local authority going forward. It's always best to try and set up roundtable conversations, etc., before you start talking about legal proceedings or threat of legal proceedings. And challenges to local authority policies, safety valve agreements, etc., we are seeing are not succeeding. So again, all conversations should be child-centered. Next slide, please. So how to build a strong case if it were to come to a greater challenge, either to the Secretary of State, a complaint to the Secretary of State, or judicial review. You must keep detailed records of your conversations with the local authority, and this includes meeting notes, calls notes, etc., your cost of provision maps. I always recommend that you have a single file per child with all of these emails, conversations, and so on. It can be quite difficult to otherwise to draw them all together when you want to challenge. You will be using their formal complaints routes with the local authority. You can also go via the Ombudsman, but please do always use the local authority complaint route. And you can refer to the local authority, continue to refer the local authority to the statutory duties and failures in the provision, and consider legal advice if issues persist. And this is going back to your duty, your overarching duty to use public funds in accordance with the intention behind the public funds as when these were given to the school. And I think this is the final slide. Taima, can you come to the last slide? So common pitfalls and how to avoid them. You must be clear from the start with the local authority. It is much easier to say to the local authority, for example, in relation to alternative provision, we do not believe that this child is going to come back to us. We agree to fund or to divert the top-up funding for a period of 6 weeks or 8 weeks whilst you're coming to a final decision on this, but no longer. So be clear from the start on what you think the real position is and how you think that you are complying with your duties. Don't assume responsibility where the local authority duties apply. This is important again, and you would be doing so in writing. You will avoid funding provisions that are not agreed or documented in the EHCP. And I know this is very, very hard because you're all educators and what you want to do is best by the children. But it's very, very important that you communicate with the local authority that failure to fund will result in you being unable to make X, Z, and Y a special educational provision. That has its own risks because you have your duties under the Equality Act. So before doing that, please do speak to us or speak to your friendly lawyer about it. But try to really push back where you can on all sorts of informal arrangements or conversations that yes, funding will come, etc. Pin them down to it and ask for written decisions and reasons of the local authority. This again will help you if you come to bring a complaint later down the line.